Thank you so very much for speaking with us this afternoon, Peter. Really welcome your thoughts on the case that you had taken with Tony McRae, the defamation case against Metro magazine and ACP. Now, on first reading, regardless of whether you know the law or not, it was simply a case of defamation. Why then would Metro have fought this so vehemently?
Well, they said that it was satirical, that it was only a very funny piece, and that the Felicity Ferret column, everybody just laughed and didn't take it seriously. So they said it was a play upon words to say that she was pissed, when they spelt that P-S-S-T. So they said nobody would take it seriously. But in the end, the jury did take it very seriously, and the way they conducted the defence and the aggressive way that they tried to discredit her, the jury felt very sorry for her and then awarded her that very high amount of $370,000, which I think at the time was the highest amount that had been awarded by a jury in a defamation case. So, and a lot of was reflected in the way the case was conducted. The defence, as I say, was particularly aggressive. Warwick Roger, who was the editor, he actually wrote very unpleasant letters, and they came back to haunt him. He was taken to bits in the witness box. His lawyers didn't behave very well. All sorts of people gave evidence for us, including Mr. Holmes, Brian Edwards, all sorts of people in the media world. So it was just that the jury in the end decided that this was a very serious defamation, and the way the case had been conducted warranted this high amount to be awarded by way of damages.
Defamation and versus satirical, defamation versus humour. We see many cases still today where they argue this is in the satirical sphere. Why was this seen to be very different from some of the cases seen today? As an example, a few months ago, the Otago Daily Times, the Otago Daily News ran a cartoon about Samoa and measles. Why was that different? Why was that?
I don't think it is. I don't think it's any different. And I think this is the risk that one runs when you try to use humour. And as I quite often say to students and the like, the jury only laughs once, and that's the end of it. And they take it very seriously. So it is, humour is very dangerous to rely upon that, and that's why cartoons can get people into all sorts of problems. So, and that's exactly what this was. It was, and then they tried to say, and the evidence was that nobody takes the Felicity Ferret column seriously. Everybody just laughs at it. And then we were able to call evidence that they had used a very horrible example of somebody being bitten by a dog, and then they played upon homophobic and all sorts of things. So they used to send a very serious message quite often in the Felicity Ferret column. So it wasn't all just funny. But having said all that, that case really reflected the way the defendant conducted the litigation.
Was it a difficult case for you personally to take on? I mean, Metro magazine, it was iconic. And it
was. It was very difficult because they're a large Australian company. They had all the people there sitting at the back of the court in suits, and we made great play upon that to the jury that we were fighting. Here we were, just a couple of Wellington lawyers looking after this poor person who'd been attacked. And here we got all these suits sitting at the back of the court, and there's Warwick Roger in his suit and all the rest of it. So we made great play upon that. And it was very difficult. And if you had spoken with Tony McRae after the case, she would have said, and I often used to give others her contact details, because she said if she had known it was going to be so terrible, the court case, she would have never have done it. She said it was absolutely the most horrendous 2 weeks of her life.
Yes, yes, she did often say that. Defamation versus libel, was both of those issues argued?
No, well, defamation, libel is the written word and slander is the spoken word. So libel is defamation. So defamation includes libel and slander.
So it was just, it's one encompassing case, and it was found in her favour on all those counts. He actually settled outside of court in the end. So while the court...
Well, exactly. So what happened after the jury had given their verdict, ACP, then they brought in new lawyers, and then they made application to the judge for a rehearing based upon certain facts that the case hadn't been conducted properly, that there'd been misconduct by lawyers, there'd been misconduct by the jury and all the rest of it. And that hearing was proceeding, and then in the preceding weekend we'd had lots of settlement discussions, and then eventually Tony said to me, settle it, I've had enough, just get me $100,000 in my pocket, that's all I want, you take the rest. So they paid our costs, and so she got 100,000, and that was the end of it.
What is the lesson to be learnt from this particular case for not just emerging fledgling journalists, but
the lesson to be learned for your students is this, that be terribly careful that when you get something wrong, do not try and justify it, do not argue, do not be unpleasant, listen to what somebody's got to say, do not write letters that are over the top or rude or anything else, because you're going to be in a witness box at some stage having to explain that. So be conciliatory, be open to discussions, be open to apologize, don't be smarty pants, all these sort of things. So it's that was a lesson in how not to conduct litigation for a publisher. I've got to go. I'm sorry. I've just got.
Thank you very much. Thank you very much for joining me.
But that's okay. All right.
Thank you so very much for your time.
Pleasure. Bye.
Bye.